Good afternoon, Schalk van der Merwe speaking, and the date of this recording is 6 November 2021. The subject matter of this video comes from various questions that have been posed over the last couple of weeks, and that relates to where the employer now accepts that they cannot mandatorily, forcefully vaccinate people in their workplaces. And secondly, I think they realize they can also now not dismiss employees from their workplace simply because there are no legal frameworks within to do so. The next stage now seems to be where they now want their workers who are not vaccinated to test, PCR test, whatever test required in the workplace, and then give it sometimes on a 48-hour basis, sometimes a weekly basis, sometimes a 2-weekly basis, and so forth, but then on the cost of the employee. This is, of course, just a tactic, a strategy to get rid of the employees or then to force them to vaccinate, basically then defeating the whole purpose of what we have done thus far. It's unfortunately, Mr. Employer, still illegal to do what you are now trying to do. And once again, I'm very, very well aware of where the advice comes from. I'm not going to repeat myself. Everybody knows by now who the culprits are, who the consultants are giving wrong advice. The advice, Mr. Employer, given to you is simply wrong. It is simply illegal. In fact, it is not only illegal, it can even land you in criminal trouble once again if you do not follow correct procedures or the law. I'm going to quote to you now from actual law and from actual articles that were published quite some time ago to prepare employers for what was coming. But unfortunately, your consultants either did not know about this because they are not qualified enough, or they simply disregarded the whole issue and all the information that was indeed available to them. The content of this video is, of course, a little bit more complex than usual because we're now starting to deal with the real innards of law. This is complex law. This is not just simply stating constitutional right, Labour Relations Act, and then running from that basis. We're dealing with actual law, even crystallized in actual court cases. We call that in South Africa stare decisis. We call that in South Africa stare decisis, the precedents law or the precedent system in South Africa, simply meaning that if a higher court or an appeals court made a finding, other courts are bound by that finding. So we're dealing with quite intricate law here, not just simply the run-of-the-mill stuff. I'm going to quote to you from actual law and from actual case law that is related to this incident or this subject matter. First off, I want to advise you that in South Africa there is legislation called the Occupational Health and Safety Act. Now that piece of legislation is there to protect employees in the workplace, to make sure that the workplace is safe for them, and that if there are indeed then occupational injuries, the system and the procedure how to deal with that. It's been in South African law for many, many years, decades. It was preceded even before that also by decades old law. It's definitely not something new or different. In fact, you need in your workplace to even be aware of it and to even implement it in your workplace. And it's like it's been like that for many years. So it's not something new. In terms of the Occupational Health and Safety Act, if an employer, and we sometimes find it most often in mining, we find it in heavy industry, in industry where people can be injured on duty because of the nature of their work. You find that there are medical testing required inherently to a position of an employee. Now, if the employee must then undergo that testing, that clearance, then the employer is the person paying for it, not the employee. That's a general rule of law. I'm not going to take it even further than that. It's well known. Everybody in the industry are aware of this. However, this becomes a little bit more complex, and I want to advise you as to the Employment Equity Act, a further piece of legislation that is in place. Incidentally, I was involved in developing a certain part of the Employment Equity Act, and therefore I am very well versed in what is actually said in that piece of legislation. And I want to quote to you what Section 7 of the Employment Equity Act, it is Act number 55 of 1998. You can go and look it up for yourself, or you can ask your lawyer to provide you with that. It's gazetted. It's an actual piece of legislation. It's on paper. It's there. You can very easily access it. But Section 7 to the Act says the following. It says medical testing. Medical testing of an employee is prohibited. In other words, you're not allowed to do it unless, number one, legislation permits or requires the testing. Or, two, it is justifiable in the light of medical facts, employment conditions, social policy, the fair distribution of employee benefits, or the requirements inherent to a job. Okay, so in other words, in terms of the Employment Equity Act, you are not allowed to test employees just simply for the sake of testing. There must be a very good and sound reason, and it is already then described to you inside the law itself. Therefore, it simply means that you can test if there's a regulation, a legal regulation about it, or relating to the actual work and workplace that we are speaking about. Let's deal with legislation permitting or requiring testing in South Africa. And you may go and look at my previous videos. It has been established beyond any doubt that there is no legislation in South Africa by the central government, by any of the provincial governments, making mandatory, so-called mandatory compulsory testing, vaccination in South Africa, even a possibility. The Health Minister, Minister Mpala came out more than once in the media, and then later on a question asked by a parliamentarian from the IFP in Parliament, he stated in writing back as an answer to that question that no legislation will be put into place in South Africa to regulate mandatory vaccination. It does not exist. It's not going to exist. It never existed. We have certain legal certainty about that aspect. So to start off, the basis of this is very clear. There is no legislation in place that can permit or require testing. There are, however, regulations in terms of the Occupational Health and Safety Act, and those regulations speak of how to ensure safety in your workplace and how employees must be accommodated if they are vaxxed or not vaxxed, just simply giving the guideline of how to ensure safety in your workplace. It is not a law requiring anybody to be tested or allowed to be tested. So the first one is not applicable. There is no such law. Then the access or, in other words, not and, or a second tier, it is justifiable in the light of medical facts. I don't know of any medical facts at this point in time indicating same. In fact, medical facts tells us that the person vaccinated also can be a carrier of the COVID-19 virus, and a person vaccinated can also spread the virus into a workplace. So there's no medical distinction between a vaxxed or an unvaxxed person. Secondly, employment conditions. Now here we can maybe have a position where a person works with people that tends to have COVID, or there's a possibility of being infected. So maybe in a very, very small scope of operation, this can indeed be justified as to have people tested. But once again, for the employer's cost, not for the employee. Then social policy. It's unclear to me what social policy would mean in the context of the current situation. There's nothing in law or legal precedent even guiding me in that direction. Therefore, Busa, please go ahead with your case. I don't know who you're going to cite as respondent. You just said you're going to make a case. You need a respondent in a case like that. Nobody has been cited yet, so I think it was only a boohoo scare tactic. But please go ahead with your case so that we can get guidance from court as to, for instance, social policy. Then fair distribution of employee benefits, nothing to do with the current subject matter. And then lastly, requirements inherent to the job. Now, which positions or which jobs inherently needs you to be tested for COVID? It's very difficult, if impossible, to go and establish that. That needed, not even needed to have been analyzed already, and those plans already filed with the Department of Labour quite some time ago. Remember, the time frame ran out. Employers, you can't do it anymore. Your time frame ran out. You did not comply because your consultants did not tell you there was a time frame for this. So in other words, those people at this point in time not registered by the employers with the Department of Labour as to be inherently COVID prone, or there's a requirement inherent to their work. Unfortunately, if it has not been done by now, you can't do it anymore. So it's very clear from law, the hard black letter law itself, that it is impossible to test a person for COVID in the workplace. I know it's a communicable disease, that is true, but you must go and see to who that is applicable. That is not applicable to workplaces, that is applicable to medical professionals. Then secondly, we must also remember that in terms of the regulations of the Emergency Act, that's in place at this point in time, an officer of the peace or a police officer and certain other people may require you to divulge if you have been in contact with a person that was COVID positive or ill, or you exhibit certain very well known symptoms of COVID. We know that. Once again, it's not applicable to a workplace. It's something totally different. But it goes further. You must remember that I said that there is even crystallized law relating to this specific aspect. And crystallized law simply means a precedent has been set, it has been heard by a court of law previously, and the court of law made a definitive finding and a definitive order, and because it was a higher court or an appeals court, or other courts are by its very nature bound by that precedent that was set previously. And that is the case, very well known case, if you know what you're doing, which I suspect some consultants don't. And the case is the one of EWN versus Pharmaco Distribution Pty Limited. It's a 2016 case. It even predates COVID. It has nothing to do with COVID, but the subject matter is exactly the same. It was a person that needed to be tested because she said that she had a certain psychological ailment, and then the employer pressurized her into that, and in the end dismissed her because of it. I don't have to go into the merits of that case, but the legal precedent in that case, 2016, and you will find it in the Labour Court Journals, 377 ILJ 449 Labour Court. It's a Labour Court case. In that, please ask your lawyer to go and read up on that. Please go to your advocate and ask him for a proper legal opinion relating to this specific case. It's very well known, EWN against Pharmaco Distribution. Anybody and everybody that knows their stuff in labour law will be aware of this. Lastly, I want to come back to the whole issue of the National Institute for Communicable Diseases, NICD, and the announcements relating to COVID. I just want to elaborate on that quickly. It says, the only criteria for a person to be tested is that, number one, the person concerned must first be consulted by a medical doctor. So if you want your employee to be tested, you will have to on your cost, have him consulted by a medical doctor. And secondly, the person concerned must have a serious acute respiratory condition with fever or history of fever and coughing with pneumonia. In other words, there must be something indicating to you that this person is ill. Or the person concerned must have acute respiratory distress syndrome based on clinical tests or x-rays. So there must be something to that effect in your possession, requiring him of hospitalization. And then number four, the Person concerned must have a documented travel history within 14 days prior to the onset of the systems to any country where COVID-19 has spread to. Now, apparently at this point in time, this is now the whole world. Lastly, lastly, the person concerned must have direct contact with a person who already had symptoms of the virus and tested positive for the virus, or the person concerned must have had direct contact with a patient who received treatment for severe acute respiratory conditions. Okay, a huge amount of medical and legal jargon here. It's simple. If your employee follows the prescribed protocols in the workplace of wearing a mask, of social distancing, of washing hands, all the things regulated already for a very long time in South Africa, I do not say that I agree with those. It's just so that those are law. If the person complies with that, the person is within the bounds of law. If the person do not fall under these very clearly defined criteria as set out in the NICD, you cannot test a person in any event. And if you test that person, it must be then in terms of Section 7 of the Employment Equity Act. It must also then be in terms of the Occupational Health and Safety Act. And then beyond that, you must still go and read up and say what crystallized case law in EWN versus Pharmaco distribution in Pty Limited says. Okay, what Skalk van der Merwe is actually saying to you today, sir, you cannot by law in a legal way tell your employee, if you do not want to vaccinate, then you must provide me with a PCR test for every 48 hours, 27 hours, every week, every 2 months, whatever, on your cost. You cannot do that because it is illegal. It's not illegal because I think so, or somebody maybe wrote a little opinion about it somewhere in the press. It is illegal because it's against established law and legal precedent in South Africa. It's as simple as that. Then you must remember that in terms of the Employment Equity Act, if you keep on not following that law, if you transgress the law, there are certain sections in that law that makes it a criminal offense. And you can actually either pay a fine or you can actually even be sentenced to a prison term if you do not comply with the Employment Equity Act. That is how serious these things are. But unfortunately, consultants did not tell their employee clients of the seriousness of what they are doing. So please, Mr. Employer out there, this is heartfelt advice that I'm giving to you. Please stop the unlawful acts in your workplace. You cannot mandatorily force a person to vax. Secondly, you cannot fire a person because they do not want to be vaxxed. Number 3, you cannot stop security officers, for instance, or nurses coming onto shift because they are not vaxxed. And lastly, you cannot force people to receive testing on their own cost if they do not vax. These are all illegal acts that you are busy with that will have a legal negative remedy against you. I'm not threatening, I'm really giving heartfelt advice because I find that when I call a workplace and I say to them, sir, did you know about this? And he says to me, Skalk, I've never heard about this, you're lying to me. And I say to him, no, sir, I'm not lying. I will send you the actual legislation. What's your email? I will send it to you. I will leave it with you for a day. I will call you back to tomorrow. And I call him. That employer then usually tells me, Skalk, I did not know. Now I understand what the issue is. Now I understand why you are fighting this whole issue of so-called mandatory vaccination. Now I understand why you say it's illegal. I find that employers have been misadvised. And that is why they are doing what they're doing, putting risk on their own businesses, putting risk in their person if they're directors or owners of businesses, and even facing the possibility of criminal liability. In other words, you can go to prison because of what you're doing. I hope this video is distributed and I hope it is taken with the right attitude so that people know their rights and employers know what to do and not to do. Very pleasant day to you. I will speak to you later today.